Good afternoon, Council. We are here on the record on June 1st, 2022, in the matter of James McGarry versus Acme Incorporated. In that case, Mr. McGarry has filed a claim for benefits form on January 15th of this year, alleging an injury by accident on January 2nd, 2022. We are here in this pre-trial conference on the employer's motion. The hearing, as you all well know, is set for this Friday, which is 4 days from now. So, Ms. Devereaux, may I turn to you, please, and hear your motion? We've all read it, but I'd like you to explain what you're before the commission on.
Good afternoon, and thank you, Your Honor. On behalf of my client, the employer, we are moving for a continuance of this Friday's hearing. My elderly mother had a fall last week, and fortunately, she is home now recovering, but she's requiring round-the-clock care. And additionally, she has a 14-year-old dog that we also must care for. My siblings and I are sharing the responsibility, but this week I have been assigned 3 days, and that includes Friday, the day of the hearing. I do apologize for the last-minute nature of the filing, but my hands are really tied because I don't have any other options for her care this week.
All right, Ms. DeVoe, thank you so much for letting me know what's going on. I'm sorry that that's happened to your mother. Let me now turn, Mr. Mason, would you give us, please, the claimant's perspective on the pending motion?
Good afternoon, Your Honor. Thank you. I greatly sympathize with Ms. DeVoe's situation. I truly do, but I must, with all due respect, object to her motion for a continuance. Mr. McGarry's accident occurred over 6 months ago. We filed the claim for benefits 2 weeks after his accident. Since that accident, he has been unable to work. He has been unable to get his medical treatment, and quite frankly, it's because his claim has been denied. Now, Mr. McGarry has a wife and 2 kids. He is the sole breadwinner for his family. Because he has been unable to work, unfortunately, they've lost their apartment, and they're now living in the unfinished basement of his in-laws, which, as you can imagine, is not, it's just a horrible situation. He's unable to work, he's unable to get his medical treatment, and quite frankly, given the circumstances, it's just it's crucial to both his family and himself that we move forward with this hearing. And so, unfortunately, despite the issues that Ms. DeVoe has, I just can't agree to a continuance.
All right, Mr. Mason, any further questions of the claimant?
No, Your Honor, that concludes the direct examination of my client.
Ms. DeVoe, do you have any cross-examination questions for the claimant?
Thank you, Your Honor. Yes, I do. So, Mr. McGarry, your alleged accident occurred on the afternoon of January 2, 2022. Is that correct?
Yes, ma'am.
And as I understand it, you're maintaining that you injured your back in that accident. Is that right?
Yes, ma'am, I did.
Mr. McGarry, before January 2, 2022, had you ever suffered any injuries to your back for which you sought medical treatment?
No, I've not.
Mr. McGarry, did you seek treatment for back pain at Chesapeake General Hospital in 1999 after a motor vehicle accident involving a dump truck?
No, I did not.
Your Honor, I'd like to submit for admission into the record an emergency department record from Chesapeake General Hospital dated January 30 of 1999. That record reflects that Mr. McGarry sought treatment there for back pain following a motor vehicle accident. He was treated and he was diagnosed with an acute lumbar...
Objection, Your Honor. Your Honor, that record was not produced in discovery. Specifically, we requested any and all documents reasonably expected to be referred to or relied upon at this hearing, and that document was not produced. Moreover, as you're well aware, Rule 4.2 of the Rules of the Commission specifically mandate that all medical records are to be produced to the opposing party and to be filed with the Commission. That has not been done, and that rule is mandatory, Your Honor. There's no exceptions. And so there's no reason that this medical record should be allowed in, and I'm asking that it be stricken from the record.
Ms. DeVoe, what is your position, the employer's position, on the objection?
Prior to this hearing, we had no reasonable expectation that Mr. McGarry would misrepresent his prior medical conditions and treatment for his back as reflected in this report. Therefore, we had no reasonable expectation that we would need to seek admission of the record or to rely upon it. For the same reason, until Mr. McGarry misrepresented his prior treatment, we did not believe this record was reasonably related or relevant to the pending dispute. It was Mr. McGarry's misrepresentation today about his condition that changed that.
Your Honor, with all due respect, that's nonsense. This is a trial by ambush. They hid that record so that they could confront my client with it and try to surprise him and work on his faulty memory. I've been in front of this commission for 20 years, and never in my life have I had to deal with it.
Mr. Mason, I'm going to stop you there. I think that's quite enough. I really do appreciate your passion, but I don't think we need to go any further. I believe I understand the issue. I have the information I need to make a ruling. Thank you. All right, good afternoon, everyone. We are here on the record in the matter of McGarry versus Acme Incorporated. As you all well know, by way of history, the claimant is currently under an open award of temporary total disability benefits. The matter is currently before the Commission on the employer's June 12, 2022 application for hearing. The employer seeks termination of that open temporary total disability award on the basis that Mr. McGarry unjustifiably refused a bona fide offer of light-duty employment from the employer on June 10, 2022. The employer, with this application, bears the burden of proof. So, Ms. DeVoe, I will turn to you and ask, are you ready to proceed?
Well, Your Honor, I thought I was ready to proceed, but I just noticed that Mr. McGarry is not in the courtroom today. May I inquire of counsel where Mr. McGarry is?
All right, good question. Mr. Mason, do you happen to know where your client is?
Your Honor, I have no idea what Mr. McGarry is, but he's not going to be here today.
Well then, Your Honor, I think we need to continue this matter. We planned on using Mr. McGarry's testimony to prove our case. He is the claimant. If he's not here, we cannot prove our case without his testimony. The employer moves for a continuance of the hearing.
Before I rule on the motion for continuance, I'm curious, Ms. DeVoe, did you subpoena Mr. McGarry to appear today at this hearing?
Your Honor, we did not subpoena Mr. McGarry. As a party to this claim with his benefits at risk, we presumed he would be present. If we thought he would not have been here, we would have brought someone from Human Resources at the employer to explain what happened.
Your Honor, I'd object to the request for a continuance. We're here today on the employer's application for hearing. As you pointed out, it's their burden of proof. My client is not required to be here. They did not subpoena him to be here, and therefore there's no reason for him to be here. We would ask that the application for hearing be dismissed. They've already indicated that they cannot prove their claim without my client being here. Again, he's not required to be here. If they wanted him here, they could have subpoenaed him. So therefore, we would ask that this matter be dismissed. Thank you, Your Honor.
We object to the claimant's motion to dismiss. We move the commission to grant the employer's application and terminate the award of temporary total disability benefits based on Mr. McGarry's failure to show up for today's hearing as a party in his own case.
Well, this is an unusual situation. Mr. Mason, would you like to continue your direct examination of the claimant?
Yes, thank you, Your Honor. So, Mr. McGarry, did you report your accident to the employer?
Yes, sir, I did.
And with whom did you speak?
I told my supervisor, Buddy Bloxham. I told him about what had happened.
And did your employer fill out an accident report?
No, not as far as I know.
And what do you know about any accident report in your case?
Well, I talked to Mr. Bloxham, and a couple of weeks after the accident, he told me that he talked to Ms. Jones in Human Resources. And Ms. Jones showed him an email from Mo Hackett, the department supervisor, and that said that Ms. Jones should not complete an accident report because my accident wasn't filled out wasn't reported within 24 hours like it was supposed to be. But it was, of course, because I talked to Buddy Bloxham about it.
Objection.
What is the basis of that objection?
Your Honor, this is hearsay upon hearsay upon hearsay. The claimant's testifying about an alleged conversation with his supervisor, and not only telling us about that conversation, but also another alleged discussion with someone in human resources who then showed him an email involving yet another representative of the employer. None of these witnesses were called by the claimant to testify here today, and there are just simply too many links in this chain for this to be admissible or credible evidence.
Mr. Mason, do you have a response to the objection?
Yeah, absolutely, Your Honor. As the Commission is well aware, you are not bound by technical rules of evidence. You may, in fact, consider hearsay. Now, we asked for all communications regarding the accident report, including all emails, in our discovery. None were produced. Now, Mr. McGarry is here today. He's under oath, and he can affirm that he was told about the email. So we would ask that that testimony be allowed.
Ms. DeVoe, please continue your cross-examination.
Thank you, Your Honor. Mr. McGarry, do you remember in your deposition saying that you did not have any prior shoulder problems?
Yes, ma'am.
Did you not have a shoulder injury for which you sought treatment at Riverside Hospital in 2008?
No, I did not.
Mr. McGarry, isn't it true that you were convicted of a Class 1 misdemeanor of taking indecent liberties with a child in 2010?
Objection, Your Honor. Relevance and materiality.
Counsel, we need a sidebar. Mr. Mason, before we go any further, what is your position?
Well, Your Honor, our common law rule is that the defendants may challenge my client's credibility with evidence of either a felony conviction or a guilty plea to a crime of moral turpitude. First of all, moral turpitude has traditionally been interpreted as crimes involving lying, cheating, or stealing, and we can't unreasonably expand that definition now. And second, there's been no foundation that Mr. McGarry pled guilty to that crime, which of course is a misdemeanor.
Ms. DeVoe, your response?
I agree this is unpleasant and creepy stuff. If Mr. McGarry was found guilty of that crime, he'd say anything in this hearing. It is critical information for you to judge his credibility.
Thank you. Here's how I'm going to rule. Good morning, Mr. Martin. We are here today on your claim. I am Judge Smith. This is Ms. DeVoe. She's the attorney for the employer. You have the burden of proving an injury by accident, so I'm going to ask you some questions. Did you injure your back on June 25th, 2021?
Yes, sir, I did.
Please tell me what happened.
My back started hurting. I told my supervisor, and he took me to the dock in the box on Smithfield Road.
Did anything happen to cause your back to start hurting?
No, not that I remember right off.
What were you doing just before your back started hurting?
I was doing what I do every day, lifting barrels of reject hot dogs and putting them on pallets.
Did your back start hurting when you lifted a particular barrel? Or was there a specific time when it started hurting?
Oh, yeah. Now that you mention it, it was about 3 p.m. I went to lift this one barrel, and that's when I hurt my back.
Your Honor, with all due respect, I must object. I would ask that the last question and answer be stricken from the record. The claimant has the burden of proof in this case. You asked him generally what happened, and he said his back just started hurting, and he did not remember anything particular happening. While we all understand Mr. Martin is not represented by counsel, I respectfully submit that your continued questioning has advanced beyond fact-finding and gone into the role of advocacy.
All right, Mr. Mason, let me summarize what I understand where we are with this. You represent the beneficiaries of the deceased claimant, Tim Horton. He was fatally shot by his brother and employer, Johnny Horton, at the Acme Tool Company. You called Johnny Horton to testify, and he refused based on his Fifth Amendment right not to incriminate himself. Under state law, if the claimant's death is at work and it's unexplained, there is a presumption that it is work-related and compensable. Ms. DeVoe, on behalf of the employer, you now want to call the district attorney. Can you explain that?
Yes, Your Honor. Pursuant to our prior notice, we wish to call Carlton Banks, the Macon County District Attorney. Mr. Banks was going to prosecute Johnny Horton for murder. Mr. Banks dropped the charges after he was told by Johnny Horton that he shot his brother and employee in self-defense. The two had apparently gotten into an argument at a Labor Day picnic where they had smoked brisket, drank too much, and got in a fight. We intend to call Mr. Banks to testify what Johnny Horton told him about the source of the altercation that led to the shooting, namely that it was personal in nature and unrelated to their work at Acme Tool.
Mr. Mason, what is your position on this testimony?
Well, Your Honor, we'd object to this line of questioning. We're talking about dangerous and unreliable hearsay here. Johnny Horton refused to testify about the shooting. Now we're going to allow the defendants to call the prosecutor to testify as to what Horton told him. Your Honor, this is clearly an out-of-court statement offered for the truth of the matter, and we would ask that that testimony be excluded.
Mr. Mason, you're here today with your client, James Bubba McNeely. We're here to consider a settlement. I have reviewed all the documents. I remind everyone that it is my job as the fact finder to determine that the settlement is in the claimant's best interest. Mr. Mason, what is your position?
Thank you, Your Honor. Well, the parties have agreed to a lump sum settlement in the amount of $500,000 payable to my client, less, of course, attorney's fees and costs. My client suffered serious injuries in a work accident on June 20th, 2021. He incurred approximately $750,000 in medical bills, primarily to Riverside Hospital in regard to his emergency care. He has been out of work since the accident. This was a single-car motor vehicle accident, and unfortunately, under the narrow, strict street risk doctrine, the employer has disputed compensability. We think the settlement is in my client's best interest.
Will the employer be responsible for the payment of any medical expenses?
No, Your Honor. This is a disputed case, and we included a finding of fact in the settlement papers that the accident is not compensable under the Workers' Compensation Act.
Isn't that something that should be decided based on the facts and the law? Can I let you all decide the context of a settlement, what is and what is not compensable?
Well, we think it's okay, Your Honor. It is a stipulation of the parties, and it will avoid problems with Medicare and any type of set-off, and will compensate Mr. McNeely fairly.
Is anyone concerned that we do not have the medical providers present, like Riverside Health?
With all due respect, Your Honor, no. We all agree that this is, in fact, the best outcome for my client.
What does Mr. McNeely plan to do about the medical bills?
Well, we plan on telling the provider that the claim was not compensable under the Workers' Compensation Act, and if they persist in trying to collect, then he will file for bankruptcy. He doesn't have any insurance.
Ms. DeVoe, what is your position?
Your Honor, we agree with Mr. Mason. The settlement is fair and is in the best interest of Mr. McNeely.